Welcome to the next part of Lesson 6, where we will dive into the important aspects of digital marketing: law, ethics, privacy, and security. These considerations are essential to not only protecting your brand, but also building trust and reputation with your customers. As digital marketing evolves, so do the risks, and adhering to best practices ensures legal compliance and fosters customer confidence. Let's begin by understanding the ethical and legal frameworks that shape digital marketing. In this section, we'll explore the legal and ethical frameworks that govern digital marketing. Understanding these frameworks is crucial for marketers to avoid legal pitfalls and uphold ethical standards. Digital marketers must balance business goals with responsible practices, ensuring they act within the law and maintain integrity. In the US, digital marketing falls under various legal frameworks, including legislation at both federal and state levels, case law, and regulations set by administrative bodies like the FTC or Federal Trade Commission. Marketers need to be familiar with federal legislation such as the Can-Spam Act, case law rulings that impact online marketing, and regulatory guidelines. Awareness of state specific laws is also important, as legal requirements may vary by location. This slide highlights key components of this legal framework. Here we have a table summarizing some key U.S. federal laws related to digital marketing. The Federal Trade Commission Act broadly regulates deceptive practices in digital marketing. The Can-Spam Act, which governs email marketing, aims to reduce unwanted messages. The Telephone Consumer Protection Act restricts the use of automatic dialing systems. These laws ensure consumer protection while guiding marketers on best practices for digital campaigns. The Consumer Review Fairness Act and Lanham Act protect consumers and trademarks respectively. Understanding how these laws apply to your marketing activities is critical to staying compliant. This slide continues with more laws impacting digital marketing. The Anti-Cyber Squatting Consumer Protection Act, ACPA, addresses domain name trademark issues, while the Digital Millennium Copyright Act, DMCA, focuses on online copyright protection. The Americans with Disabilities Act, ADA, ensures digital accessibility, preventing discrimination based on disabilities. Digital marketers must consider accessibility standards to make their content available to all users, and often making it more accessible is helpful to SEO. The Federal Trade Commission Act is the backbone of many digital marketing regulations. It prohibits deceptive or unfair marketing practices, focusing on ensuring that consumers are not misled or harmed. Deceptive activity refers to practices that mislead consumers, while unfair activity causes significant consumer injury without offering enough benefits to outweigh the harm. Marketers must ensure that their campaigns are not only effective, but also fair and transparent. The FTC provides detailed guidance for marketers to avoid violating rules, particularly for claims regarding health, safety, or performance. These claims must be substantiated with evidence. Marketers need to ensure their promotional materials are accurate and well supported, especially in industries like health, food, and dietary supplements, where regulations are stricter. For example, if a supplement brand claims that its product boosts immune system health, they need clinical evidence to back that claim, or else they risk violating FTC rules on health claims in marketing. The Can-Spam Act of 2003 governs email and text message marketing. This law requires that email headers are accurate and valid, subject lines are not misleading, and physical postal addresses are provided. Opt-out mechanisms must be included to allow recipients to unsubscribe easily, and marketers need to be especially mindful of these requirements to avoid hefty fines and potential damage to their brand's reputation. The Telephone Consumer Protection Act, TCPA, regulates the use of automated dialing systems, particularly robocalls and robotexts. A recent Supreme Court case, Facebook Inc. versus Duguid, clarified the definition of an automatic telephone dialing system. Facebook won the case because the technology in question did not randomly generate numbers as the law defines. The case highlights the importance of understanding the nuances of legal language in digital marketing. For example, to comply with TCPA, many modern marketers use opt-in systems for SMS marketing, ensuring that users explicitly agree to receive messages. This method avoids using automatic dialing systems that could lead to legal challenges. In digital influencer marketing, disclosure of material relationships is crucial. Influencers must disclose if they are paid, employed by the brand, or have personal or family connections to the brand. This transparency is essential for maintaining trust with audiences and staying compliant with the law. Additionally, influencers should avoid giving professional advice to prevent liability. Under the Consumer Review Fairness Act, companies cannot prevent consumers from reviewing products, penalize negative reviews, or make contracts that prevent honest reviews. Organizations also cannot require individuals to give up intellectual property rights tied to their reviews. Marketers should avoid any actions that violate these rules, as doing so could harm brand reputation and lead to legal consequences. Trademarks are an important part of digital marketing. They distinguish products or services from one another. The Lanham Act protects trademarks used in commerce, both registered and unregistered, as long as they are used for marketing goods or services. However, not all digital use of trademarks will be considered quote unquote commercial. Always check the trademark is used legally in a digital context. The Anti-Cyber Squatting Consumer Protection Act protects using domain names in bad faith that contain trademarks. Additionally, the Trademark Dilution Revision Act of 2006 prevents the use of trademarks in a way that weakens their value or tarnishes their image. Digital marketers must be careful when using trademarks to ensure they do not dilute or harm their value. Domain name registrars, social media platforms, and mobile app platforms often have specific terms and conditions governing trademark use. The Uniform Dispute Resolution Policy allows trademark owners to claim ownership of domain names without needing to go to court if the name is identical or confusingly similar, used in bad faith, or the user has no legitimate interest in it. Marketers should be aware of these rules. Copyright is another vital area of intellectual property. Copyright protects original works of authorship when they are fixed in a tangible form, such as written or digital communication. It applies to a wide range of creative works, including written, musical, artistic, and audiovisual works. Marketers should remember that copyright applies automatically without needing formal registration or a copyright symbol. Their use allows the use of copyrighted works without permission under certain conditions. These include criticism, news reporting, or teaching. Courts consider several factors when determining fair use, including the purpose, nature, amount of work used, and its effect on the market. Always ensure that your use of copyrighted materials meets these fair use standards. The public domain includes works that are not protected by copyright law, either because their copyright has expired or they were never copyrighted at all. For example, works created before 1978 are typically protected for the author's life plus 70 years. Digital marketers should ensure that any work they use either falls under public domain or that they have the proper permissions. Creative Commons licenses allow content creators to share their work by different conditions. CC BY requires that creators receive credit, but is the least restrictive. CC BY SA mandates that adaptations of the work must be shared under the same terms. The CC BY NC ND license is the most restrictive, preventing commercial use and adaptations. Marketers should review these licenses carefully before using any content. Copyright and trademark protections extend internationally. For instance, the Berne Copyright Convention provides copyright protection for works across member countries without requiring further formalities. Trademarks can be registered in up to 130 countries through a single application under the Madrid system, making it easier for global brands to protect their trademarks. Contract law governs the agreements between parties, including those related to digital marketing on platforms like Instagram or Facebook. For instance, Instagram's community guidelines require advertisers to follow the law and prohibit certain promotions, and always reserve the right to remove content that violates these guidelines. Marketers should always review the terms and conditions of platforms before engaging in digital marketing activities. Snapchat's advertising policies, like those of other platforms, include rules for avoiding intellectual property infringement and respecting cultural norms in targeted locations. Make sure to review these rules carefully, especially when running promotions. Understanding and complying with platform-specific advertising rules is critical for campaign success. The Americans with Disabilities Act, ADA, ensures that individuals with disabilities are not discriminated against, and this law extends to the digital marketing realm as well. As digital marketers, we need to make sure that all content we produce is accessible. This means for websites, we should include captions for videos, use alt text for images, and make our content screen reader compatible. Email should not be purely image-based or rely on color alone to convey information. Finally, for mobile apps, it's essential to offer larger buttons or zones for those with accessibility needs. And the app should work with screen readers. Failing to consider these aspects can lead to lawsuits, so it's important to be proactive and just to be inclusive. Digital marketing often crosses borders, so understanding the legal requirements of each country where your content is being used is crucial. Running the same campaign globally might seem efficient, but different countries may have various legal requirements for disclaimers, information transparency, and advertising rules. It's essential to consult legal counsel in each relevant country to ensure compliance, avoiding the assumption that one strategy fits all regions. This is especially important for avoiding unintentional violations that could cost your company in fines. This slide introduces key legal frameworks for digital marketing across different regions. The UK's Consumer Protection Law aims to prevent deceptive marketing messages and aggressive sales tactics that can mislead consumers. Meanwhile, their business protection laws address comparative advertising, ensuring that businesses do not unfairly use competitors' logos or trademarks. The European Union also has strict rules, particularly around B2B marketing, ensuring that product comparisons are accurate and not misleading. These examples emphasize the importance of understanding regional laws when creating marketing content for international audiences. Continuing with examples from the European Union, the EU Directive on Unfair Commercial Practices emphasizes truthfulness and discourages aggressive marketing. The Digital Services Act adds transparency requirements, especially when it comes to targeted advertising for children. As digital marketers, we must adapt our practices to follow these rules, ensuring that we are not only compliant, but also upholding ethical standards in our marketing. Further regulations from the European Union include the Digital Markets Act, which affects platforms considered to be gatekeepers. This act requires transparency in how platforms handle data and engage with advertisers. Canada's Competition Act also takes a strong stance on misleading advertising, pricing, and disclosures, as well as influencer marketing, making it vital to ensure truthfulness in your campaigns. Again, as marketers, staying updated on these regional laws helps us avoid legal issues and maintain trust with our audiences. Digital marketing opens up significant opportunities for reaching diverse audiences, but we need to recognize the ethical challenges that brings. Consumers may perceive aggressive tactics as unethical, even if they are legal. Extensive tracking of their behavior can feel invasive, leading to distrust. Moreover, consumers can find constant retargeting, such as repeatedly seeing ads after a single search, annoying or even unethical. While the law provides certain boundaries, ethical considerations push us to reflect on how our strategies impact our audience's trust and comfort with our brand.